Hey guys, welcome back. Our next topic is fundamental rights and armed forces. These fundamental rights are guaranteed to all citizens, but they are not absolute. The Constitution itself allows certain restrictions in special situations. One such situation is this in the case of armed forces. So, what does the article 33 talks about this? The article 33 says empowers the parliament to restrict or even remove certain fundamental rights for the members of armed forces, paramilitary forces, police forces, and intelligent organizations. Because here the important is only parliament can do this, not a state legislature. So why is this needed? Only parliament can do this, not the state legislature. So why is this needed? Armed forces are not ordinary services. They require strict discipline, chain of command, immediate obedience, and national security secrecy. If fundamental rights are allowed without restriction, discipline may collapse. And we will see what are these restrictions are. The freedom of speech may be restricted sometimes, and right to form associations or unions may be restricted, and right to strike is also not allowed because militaries cannot function like a civil society organization. So can the armed forces approach courts? Yes, they do have a certain legal remedies, but their rights are modified to ensure discipline. So this is not the suspension of rights like emergency. This is a constitutional restriction for specific services. The Article 33 shows that fundamental rights are not absolute. They operate within the framework of the national security. Next, we will see martial law, martial law and fundamental rights. The Article 34 talks about this. The Article 34 says when martial law is in force in any area, the Parliament may restrict the fundamental rights, validate actions taken by authorities, provide indemnity, means legal protection. Restriction of fundamental rights, Parliament may indemnify acts done during the martial law. Okay. So, what is the martial law? Martial law means a military takes control of administration in a particular area when civil authority completely fails. Example situation like war like internal disturbance, violent rebellion, breakdown of law and order. In such situations, civil courts may stop functioning and military authorities take control. So the constitution does not define the martial law, but it is recognized its possibility under Article 34. Okay. So, if martial law is in force in any area, Parliament may restrict fundamental rights, validate actions taken by authorities, provide indemnity, means legal protection. This means acts done by armed forces during martial law can be protected from a legal challenge. So, why is this needed? Because during the extreme breakdown, immediate force may be required. Normal procedures may not be followed. Harsh measures may be used later to protect officials from the endless legal litigations. The Parliament may grant indemnity. Okay, we will see differences between the emergency and the martial law. Emergency is declared under Article 352, 356, and 360, and martial law it is not formally defined. And emergency constitutions constitutional it is a constitutional mechanism and enter country applicable to entire country or state. Whereas this martial law takes place only in a specific area. Okay. The civil government still continues in emergency, while martial law, the civil courts may stop functioning. So, has it ever imposed in India? This Article 34, it's not formally imposed in India at a formal level, but the concept existed during the British period. For example, the Jallianwala Bagh massacre in 1919. Okay. So next we will see the differences between procedure established by law and the due process of law. First, we will see it through by Article 21. So the Article 21 says no person shall be deprived of life or personal liberty except according to the procedure established by law. Now the question is, what kind of procedure? Just any law passed by Parliament or fair and the reasonable law? So this is where the difference arises. First, we will see the definition of the procedure. What is procedure established by law means? It is they are originated in the United Kingdom, meaning if the Parliament passes a law and that the law prescribes a procedure, then that procedure is enough. The court only checks whether the law exists, whether the procedure is followed, and the court does not check whether the law is fair, whether it is reasonable, whether it is just. So originally this approach gives the more power to legislature. No matter the um, law is unfair, if it is not justiciable, it is not up to the mark, the court cannot question it in this procedure established by law. Okay, they will only see whether this a law exists in the book and the procedure is followed. That's all in the procedure established by law. Okay, next we will see the due process of law. Due process of law, it is originated in United States, meaning the law must only exist when it must also be just, fair, reasonable, and non-arbitrary. The courts can examine the substance of law, fairness of law, reasonableness of law. So here judiciary has the more power. So why did the Indian constitution choose the procedure established by law? Because constituent assembly feared too much judicial interference. uh, uh, they want gives the more power to the judicial system, so they wanted the parliamentary supremacy within with the judicial balance. So they avoided the American phrase due process. Later, in Maneka Gandhi versus Union of India in 1978, the Supreme Court expanded the Article 21. The court said the procedure must be just, fair, and reasonable. If the procedure is arbitrary, it violates the Article 21, meaning the Indian Supreme Court practically introduced due process into the Article 21. So the present position now is India followed procedure established by law originally. After Menka Gandhi case, India follows a hybrid model. Now the India follows substantive due process in practice. Okay, substantive due process. That's all for today. Thanks for watching, guys.